Welcome everyone, and thank you for joining us again in this new session of the Indiana Leeds Summer Tax Workshop Series. I'm Dr. Leopoldo Parada. I'm a lecturer in tax law at the University of Leeds in the United Kingdom, and I'm co-hosting the series with my colleague Leandra Lederman, who is now going to introduce herself and also our speaker of today.
Thank you so much, Leopoldo. So as he said, I'm Leandra Lederman. I'm the William W. Oliver Professor of Tax Law at Indiana University Maurer School of Law in Bloomington. And it's my pleasure to introduce today's speaker, Joshua Blank. Josh Blank is Professor of Law at the University of California, Irvine School of Law, where he has taught since July 2018. In addition, as Faculty Director of Strategic Initiatives, he oversees UCI Law in New York City, an innovative program that supports students who are interested in exploring career paths in New York. From 2010 to 2018, he was a member of the full-time faculty of NYU School of Law, where he served as Professor of Tax Law, Vice Dean for Technology Enhanced Education, and Faculty Director of its Graduate Tax Program. His scholarship focuses on tax administration and compliance, taxpayer privacy, and taxation of business entities. And today he's going to present us his very interesting paper co-authored with Professor Leigh Osofsky of the University of North Carolina School of Law, Automated Legal Guidance. Go ahead, Josh.
Well, thank you very much, Leandra and Leopoldo, for organizing this incredible series and for inviting me to participate. I have been at some of the sessions and have just been in awe of how in the middle of the pandemic and such a difficult time, you're able to bring together the entire academic tax world, it seems. And I'm really grateful that you've done this. And I hope that what you've created survives this current period that we're in and continues in the future. I'll also say at the moment, I'm so happy to be here to share this project that my colleague Leigh Osofsky and I are working on. One thing I'll just say at the very beginning, this is sort of like, maybe for a tax lawyer in the US right now, making a presentation in the middle of the Super Bowl. The Supreme Court, I believe at the moment, is handing down 2 decisions in cases involving the President of the United States. And in one of the cases, his tax returns. This is an area that I've spent a lot of time writing about and thinking about. I have no idea what is happening at the moment. So if you could just not tell me how this worked out, I will find out after the talk. And one way or another, there will hopefully be an answer. I hope they're not delaying it until some later point in the year. But in any case, please don't tell me what happened in the comments, or I'm being totally serious. I am not acting. I have no idea what's going on right now in the US as the Supreme Court hands down this decision. So to today's topic, the paper that I'm about to present is titled Automated Legal Guidance. I've co-authored this with my colleague, Professor Leigh Osofsky, who teaches at the University of North Carolina at Chapel Hill School of Law. This is still a working draft. We're in the process of finishing this paper, but then are working on an extension of this research, specifically about how the government speaks to its own employees internally and other related projects. And so we're eager to hear your feedback. It's also especially relevant this week in the US because tax day this year is actually July 15th. And normally it's April 15th, but because of the pandemic, things were moved. And so it's July 15th this year. And the IRS has relied more heavily on automated legal guidance during this season than ever before. So I'm going to share my screen now and can talk to you a little bit about our project. Okay. Share it, there we go. So this paper examines how the rise of artificial intelligence and administrative guidance is producing a new phenomenon, what we describe as automated legal guidance. Through online tools, virtual assistants, and other technology, governments are increasingly relying on artificial intelligence to help the public understand and apply the law. We show that automated legal guidance often relies upon what we've described in prior work as simplexity, where the government describes law, which is very complex, as though it's simple, but doesn't actually simplify the law itself. This approach offers gains in terms of efficiency and ease of use, but it also causes the government to present the law as simpler than it is, which can lead to less precise advice and potentially inaccurate legal positions. We argue that the use of Simplexity and automated legal guidance is more powerful and pervasive than in static publications because it's personalized, non-qualified, and instantaneous. After we introduce this new development, we make several positive claims, we address normative concerns, and we offer concrete recommendations to policymakers. So first, what is automated legal guidance? Automated legal guidance, as I described, has emerged from the rise of artificial intelligence. Now, defining artificial intelligence itself is difficult. It's an amorphous concept. There's no universal definition. Artificial intelligence includes the use of machines in a way that approximates or augments human intelligence. Machine learning does not rely on formal logic. Machines can be trained to make highly intelligent predictions based on historical patterns. Many machines can actually teach themselves and can develop more accurate predictions as they obtain more data and more data. And in the US, government agencies have not ignored this development. It's not gone unnoticed. I have on the screen a number of executive orders and other things that have happened in the US in the last couple of years where government officials and agencies have made it clear that government should embrace artificial intelligence in its services. Government agencies use artificial intelligence and machine learning today to surveil, to police, and punish. For example, the government has the ability to use machine learning to identify likely crime hotspots and recommend sentencing periods based on the likelihood of recidivism. This information is being used today to make policing and sentencing decisions. Outside of the criminal context, the SEC has indicated that it uses machine learning to identify potential fraud, as well as systemic market risks. This is all starting to feel a little bit like the stuff of science fiction. I have Minority Report on the screen for any fans of this film. Legal scholars have examined how to apply Fourth Amendment standards to predictive crime technology, how to protect racial equity in an era of algorithmic technology, and how to drive transparency when automated predictions drive enforcement decisions. The government, though, does a lot more than just enforce the law. The government also provides extensive services to the public. Of course, services like roads, national defense, and a variety of other goods like Social Security, but it also provides the service of making the public aware of the law and then assisting the public to comply with the law. The IRS is a prime example. In 1998, our Congress enacted the Restructuring and Reform Act, which emphasized the IRS's obligation to not just enforce the law, but also to provide customer service to taxpayers. And as a result of this restructuring, I have on the screen the Taxpayer Bill of Rights, which the IRS adopted, which states that all taxpayers have the right to clear explanations of the law and IRS procedures in all tax forms, publications, notices, and correspondence. So as that illustration shows, the government issues guidance to the public in order to explain the law. What's special about guidance? Guidance falls outside of formal administrative law requirements. Even though it doesn't have a formal place in administrative law framework, scholars have examined how guidance can be highly influential on the public. Members of the public have a strong inclination to change their behavior in a manner consistent with guidance in order to avoid enforcement. So the combination of artificial intelligence and the government's use of guidance has led to a little noticed phenomenon that the government is using artificial intelligence to automate its issuance of guidance to the public. In its drive to improve service, governments at all levels have been essentially mimicking private industry's automated customer service representatives. And I can give you a few examples, and as you'll see, they even have faces and personalities. So on the screen, I can show you an example from the States. So this is Missy. Missy is Mississippi's first artificial conversational chatbot. And Mississippi tells us that Missy is here to help us with our questions 24/7. If you want to know how to conduct an unclaimed property search in Mississippi, just ask Missy. At the federal level, this is Emma. Emma is a computer-generated virtual assistant for the U.S. Citizenship and Immigration Services, and Emma promises to answer immigration and citizenship questions. You can even change the sound to have Emma speak in English or in Spanish. Emma also, I found out, is named for Emma Lazarus, who wrote the poem that is on the Statue of Liberty. But in any case, this is Emma, as you can find her on the government website. In addition, our government has other virtual assistants that we describe in the paper. The U.S. Army has Sergeant Star. You can find out whether you can qualify to enlist in the Army, whether you meet the height, the weight requirements, etc. Internationally, I have on the screen an example from the Australian Taxation Office. This is Alex. Alex is a virtual assistant who helps taxpayers in Australia with their tax questions. You can ask Alex questions just like you would if you were talking to a person the government tells taxpayers. So I did. I asked a question. I typed in lottery winnings. Are lottery winnings taxable? And Alex told me the answer. No, not in Australia. If you win the lottery, it's not taxable. I did not know that. I'm being serious until checking with Alex. And as a result of all of the success that Australia has had with Alex, Australia is using Alex to answer questions about other issues, property rights, intellectual property rights. The only thing is that what happens when Alex starts talking about non-tax issues, the color of Alex's shirt changes. So if you spend some time working with Alex on the government website, you'll see how this works. But the idea is that Alex is there to answer people's questions about the law. So now, as we think about what's going on in the United States, I'll give an example of the same exact technique. On the screen, I have an example from the IRS's website, the Interactive Tax Assistant. The IRS has been publicizing the Interactive Tax Assistant more and more, and especially this year, because the physical offices where you might go are closed, and there aren't people picking up the phones. The Interactive Tax Assistant is what the IRS relies on to provide taxpayers with guidance. And I'm going to call the Interactive Tax Assistant ITA for short. ITA, we're told, is an online tool that provides answers to tax law questions on a range of topics: what's taxable, tax credits, filing status, many other topics. Instead of the old IRS publications that you might get at the public library, which would summarize the law, you now go to ITA and ask first, you have to select a category, like can I deduct medical expenses, for example. And then you are taken through a series of different steps where you have to answer questions. And once you input the responses to these questions, ITA gives you an answer. And the answer is supposed to help you decide what to do. One thing I will say, we've talked, well, this actually I should show you too. This is an example of how the IRS publicizes ITA. This is from the IRS's Twitter account. If you have questions, you should check with ITA. No need to wait. I don't really know what's going on 100% in this picture. The robots are lined up, I think, to talk to ITA behind the door. I don't know if the robots are getting advice, but it involves tech. We saw Emma, we saw Alex. I've spent a lot of time with these characters, and so has my colleague Leigh, but we don't know who ITA is. So the best we have is an artist's rendition, which I can put on the screen, I think. There we go. This might be ITA. I don't know. Maybe R2D2's tax-savvy cousin. In any case, maybe one day, maybe this will be the face of ITA. So this is an example of how the government uses Simplexity to explain the law. Previously, we have written about Simplexity, and as I said earlier, Simplexity occurs where the government presents complex law as though it's simple, but it doesn't actually simplify the law. And again, this makes the law easy to understand and follow, but it might present the law in ways that are not 100% accurate or as precise as the actual law is. In many cases, ITA guides taxpayers to the right answer without requiring them to comprehend very complex tax law. But in other cases, it delivers answers that fail to fully explain the law, including exceptions. And sometimes IDA adds gloss to the law, which is not in the actual law. And so while the IRS often provides answers that are consistent, it can deliver answers that deviate from the law as a result of its use of Simplexity. Sometimes the deviations help taxpayers, other times they are adverse. And so if you bear with me now, I can give you a few examples. If you've read the paper, I should say, if you bear with me, these are in the paper, but I'll give you a few highlights and then you can play around with IDA yourself on the website. So here are some examples of how IDA works in a way which is consistent with the tax law. If you have questions about topics that are straightforward and unambiguous, IDA can deliver an accurate response pretty quickly. Consider filing deadlines. Imagine there's a computer programmer in the United States from India, and the programmer is a lawful permanent resident, a green card holder, and is in the United States to help establish a branch office in California. And after 1 year of being in the United States in 2020, he tries to find out, when's my tax return due? So he visits IDA, and IDA has a bunch of categories, and one of them is, what's the due date for my federal tax return? So we check that category. And then IDA asks a question, will you be living outside the US in Puerto Rico on April 15th, 2020? And the programmer says no. IDA then provides an answer. The deadline is April 15th, 2020. This is a simple example. IDA helps the taxpayer. It's actually accurate. And it can handle situations that could be different if the programmer were living outside the US on April 15th, 2020, then IDA would have told them June 15th, 2020 was the deadline. But in any case, this is an example of an accurate, consistent with the law use of IDA. Sometimes, though, IDA can deliver answers that deviate from the law in ways that are seemingly favorable to taxpayers. So imagine that there's a model living in Los Angeles, and he wants to alter his physical appearance, specifically his front teeth. I have looked into this. This is actually a big industry in LA. And he wants to be a model in print and online advertisements, so teeth are important. And he can't get the braces to really make this work. So he visits an oral surgeon who says, you can have a procedure and we can replace your front teeth with 4 artificial teeth that will be beautiful. It will cost about $10,000. Can he deduct this as a medical expense? Well, IDA tells us that if the expense is for artificial teeth, there's an answer. After selecting the medical expense category, there's a whole question about artificial teeth. And if our taxpayer chooses artificial teeth, IDA quickly says, yes, your artificial teeth are a qualified deductible expense. Now, if the IRS were to audit this and learned that the teeth replacement was because of a desire to get acting jobs or a change appearance as opposed to a deformity or a disease, the IRS could challenge this as cosmetic surgery under Section 213D9 of the code. IDA asked for very simple inputs, artificial teeth, but it did not ask any questions about some of the more uncertain features of the relevant statute. Was this to help proper functioning of the body? Was it the result of an accident or trauma? Is that the reason why you needed new teeth, etc.? I'll give you another example. I hope you're having fun with these. I can't tell because we're not together. So I will do a few quickly and then talk about some other issues. Lead-based paint. So imagine that somebody owns a small construction company and he has 2 young children. And he decides, hey, I'm going to change the paint in my house because it's cracking. And it's lead-based, and that's dangerous for kids. And so he does. He repaints his house. Can he deduct the cost of repainting as anything? Maybe medical expense? Well, turns out there's a whole category on IDA for lead-based paint. And IDA asks, did you pay for the costs of removing the lead paint? Yes. Next, was the surface from the paint removed in poor repair? Was it peeling or cracking and in child's reach? Yes, that was the whole reason for doing this. Well, then IDA says, in that case, this is as a tax professor, this is the kind of thing that I really love when I teach basic tax. lead-based paint removal is a qualified deductible medical expense. And Ida told us the answer. But hold on, if you now go back to the 1970s and read the revenue ruling where the IRS addressed this issue, revenue ruling 79-66, the IRS said you can only claim it as a medical expense if you remove it pursuant to a doctor's recommendation. You need a doctor's note, otherwise it's not deductible. Now here, Ida simplified the description of the law, asked some questions about the cracking paint, but never asked any of the questions about whether there's a doctor's recommendation. The taxpayer might claim this as a deductible expense because the requirements seem to have been met, but that might not be consistent with what the IRS will say when it reviews this deduction. Another example from basic income tax, if anybody is missing teaching this because of changes to the miscellaneous itemized deduction rules. Imagine you're a maitre d' at a fancy restaurant, it's 2017, and you buy your own tuxedo that you're gonna wear to work. Can you deduct the cost of the tuxedo as an ordinary and necessary business expense? Now, Ida can help because there's a whole category on work clothes. And if you go to Ida and answer the question, yes, I was required to wear a tuxedo as a condition of my employment, then Ida will ask, is the tuxedo suitable? Are the clothes suitable for quote unquote everyday wear? Well, that's easy. The answer is no. Nobody wears a tuxedo every day. And if we input the answer no, Ida then says, well, great news. You have an allowable deductible miscellaneous expense. You can deduct this. Now, especially for people teaching basic income tax who missed this case that this is based on, Pevsner v. Commissioner, you might be wondering, where did the word everyday come from? Everyday wear. That's not in Pevsner. In that case, the standard is that the clothing has to be required. It has to not be adaptable to general use and not so worn. Not adaptable to general use, that's different from everyday wear. If you claim a deduction for a tuxedo, something that's adaptable for general use, you could wear it to the Oscars, to a ball, all sorts of other things, the IRS could challenge this. Ida again delivered a taxpayer favorable deviation because it used terms and phrases that don't even appear in the statute or the regulations. Let me give you a few examples of how this might work out in a way which is adverse to the taxpayer. Sometimes Ida can lead you to legally questionable answers that benefit taxpayers, but sometimes they conflict with taxpayers' interests. Teeth whitening. Consider a taxpayer who's a cancer survivor and has experienced several side effects from chemotherapy, including discolored patches on teeth. And the taxpayer spends $1,000 on professional teeth whitening from a dentist to fix this. She visits Ida right afterwards to find out, hey, can I deduct that medical expense? And selects teeth whitening expenses. And Ida immediately says, no, teeth whitening expenses are not a deductible expense. Now, even though that's pretty clear, it's unambiguous, the IRS has implied that teeth whitening could be deductible in certain circumstances. There's a revenue ruling that we talk about in the paper 2003-57, where the IRS says that teeth whitening is not deductible unless it is to address a disfiguring disease or treatment. So in this example that I described, the taxpayer, even though it was going through chemotherapy, may read this and say, I can't take the deduction because that's what Ida said, but the underlying law might actually be different. One final example, consider a star high school soccer player who receives a full scholarship to a university with an NCAA Division I team. And under the terms of the scholarship that the university provides, the student will get the scholarship as long as she meets eligibility to participate in the sport and goes to fundraising and promotional events. That's often what happens with these scholarships. And her parents and she think, well, hold on, what happens in terms of tax with that scholarship? Ida answers this type of question too. Do I have to include a scholarship on my tax return? And once that category is selected, Ida asks, well, what portion of the scholarship fellowship grant was a payment for services you were required to perform as a condition of receiving the scholarship, fellowship, or grant? And the parents select all. You had to play in the sport and go to these special events in order to get the scholarship. Well, then Ida says it's taxable. the scholarship is taxable, and that could be very significant depending on the cost of tuition. It's a simple response, but it's actually also at odds with the underlying tax law. The IRS has held that an athletic scholarship is not taxable as long as it is not canceled in the event the student can't participate, and the student is not required to engage in some other activity in lieu of participating in a sport. So Ida here didn't ask any questions about the terms of the scholarship. And Ida could have caused the parents to include this as taxable income, where if the university said if you get injured or you can't play, you still keep your scholarship, that actually would have made it not taxable. So I'll stop with the examples for now and just contrast what you saw in the last few minutes with what the IRS has historically done in its written publications. We argue that the automated legal guidance I just demonstrated provides the potential for even more pervasive and powerful forms of simplexity. First, personalization. The IRS is speaking here directly to the taxpayer, not just to the general public, anybody who can pick up the old publication from the library. In nearly all of the cases, the questions use second-person pronouns, you and yours. You saw examples of that. Behavioral research shows that personalized communication can have a greater impact on recipients' beliefs and actions than just generic statements. Second, automated legal guidance offers non-qualified answers to inquiries. Consider the model in the artificial teeth example. Ida said the artificial teeth expense is deductible. It did not consider issues about the reason for the procedure. Was it for a deformity? Was it for a disease? Instead, Ida just took a binary approach, deductible or not deductible. And it even presented that under the heading answer on the screen. If you read an IRS publication, in contrast, you'll often see a general discussion of requirements, but then also some exceptions that apply that are nearby on the page. That's not happening with Ida. Finally, automated legal guidance can deliver information immediately compared to having to sit and even read an 80 or a 90-page IRS written publication. So these tools reduce the taxpayer's incentive to do additional research or seek help from an advisor. The answer is instantaneous. You can get it right on your phone. Shifting from our positive discussion, I'll now address some of the key normative issues for a few minutes. How should automated legal guidance evolve? First, let's talk about different types of taxpayers, different user populations. How should the government use automated legal guidance to reach different user populations? When automated legal guidance relies on simplexity to make the otherwise complex law easy to understand, it tends to do so by reducing the uncertainty that you would inherently find in standards and the complexity that would come from many rules. That may make sense for certain populations. For individuals with low income, the costs of applying uncertain or complex tax rules may be high and they may not have access to sophisticated legal advisors. However, when using automated legal guidance for low-income taxpayers, we argue that it's important not to systematically increase their tax liability. So for this user population, we argue that the government should adopt a pro-taxpayer default in automated legal guidance. We also argue that the government should not necessarily attempt to deliver automated legal guidance to every possible population. Right now, EDA doesn't address topics like dividends, capital gains, Section 199A. All of those are relevant for high-end taxpayers and business taxpayers. Maybe EDA shouldn't address those topics. Those taxpayers have advisors and other sophisticated ways to understand the law. Rather, to the extent that simplexity remains a feature of automated legal guidance, it might make sense to offer that type of guidance specifically for those taxpayers where understanding the law is likely to be overly burdensome. EDA currently covers some topics that are important for average taxpayers. The IRS could continue to add topics to EDA, like the child and dependent care credit or income tax credit, other similar, often notoriously complex provisions that affect many low-income individuals. For the reasons that we've discussed, when adding these topics, especially if they involve uncertainty, we argue the IRS should design the answers to adopt the pro-taxpayer default. Second, I'll talk for a few moments about administrative process. How should the government ensure adequate administrative process for automated legal guidance? In administrative law, the classic solution for ensuring transparency and accountability is the notice and comment procedures used to promulgate legislative rules. Legislative rules include agency statements of law that combine both the agency and the public. It's often difficult to draw the line between legislative rules and other agency statements, interpretive rules. It's difficult to do that and figure out what's subject to notice and comment and what's not. Automated legal guidance falls right in this gray area. When the IRS tells taxpayers on EDA that artificial teeth are deductible under the heading answer, it seems to be making a statement of the law that in some ways is the definition of a legislative rule. But there are many reasons to suggest, if anything, that the IRS's advice here is merely interpretive. Even though the IRS takes the position that EDA's statements are interpretive, though, many taxpayers will rely on EDA when they fill out their returns. EDA illustrates how the automated nature of legal guidance exacerbates the problem of ensuring appropriate process around agency statements of the law. Automated legal guidance is often subject to even less oversight than other forms of agency legal guidance. For example, IRS publications from the library, again, I keep thinking about this, my mom and I used to go pick up these publications every year from the public library. They undergo a lengthy review process by groups within the IRS. In contrast, automated legal guidance like EDA doesn't undergo that type of review, as even individual screens in the example I showed you might be changed. These are often changes that occur at the hands of computer coders in a way that the public may not be fully equipped to understand. As agencies turn to automated legal guidance to advise the public, we argue that the government should use automation itself as an additional trigger for oversight, review, even public comment through the notice and comment process in order to ensure that agency guidance is considered to be legitimate. One final implication of all of this that I'll just address briefly are penalties. Should penalties for legal non-compliance apply even when individuals have followed the advice provided by automated legal guidance? As we've shown, where legal issues rely on factual assumptions or may involve ambiguous legal standards, automated legal guidance can provide advice that is at odds with the law. There are important differences between automated legal guidance and other forms of informal guidance, like oral advice, that we feel the government should consider when deciding whether taxpayers can rely on it for penalty relief. Policymakers, we argue, should recognize and address these differences by making changes to the structure of both the penalties for legal non-compliance and the design of automated legal guidance itself. Taxpayers who seek to use EDA today to defend against tax penalties face a number of obstacles. First, on the EDA website, the IRS explicitly informs taxpayers that the penalty abatement provision, section 6404F, which applies when the IRS provides you with erroneous advice, they say that doesn't apply to any statements from EDA. That's off the table. In addition, if the IRS were to apply one of the accuracy-related tax penalties, the taxpayer is not permitted to say, I relied on EDA. I have a reasonable basis for my position. That does not work under the regulations governing reasonable basis defenses. And technically, it's possible the taxpayer could attempt to say that I had a reasonable cause, and so using that defense, that ability is remarkably limited. I'll explain why in just a second. So the absence of defenses against tax penalties where taxpayers rely on automated legal guidance compared to other types of advice raises significant fairness concerns. By frequently informing taxpayers that EDA provides answers to questions about the tax law, the IRS is seeking to gain confidence from largely middle-income and low-income taxpayers. In contrast, wealthy taxpayers who can afford written legal opinions from lawyers or accountants can use those documents to establish reasonable cause defenses to penalties. Current law, consequently, provides greater opportunities for the most well-off taxpayers compared to others to obtain advice that they can use to defend against tax penalties. We argue that the available defenses can be reformed by adjusting the penalty defense rules themselves and the design of automated legal guidance. So first, reform of the law. In the tax context, the Treasury could revise the regulations that govern defenses against accuracy-related tax penalties to allow taxpayers to assert a reasonable basis defense as a result of the guidance they receive from EDA, as long as they disclose that with their tax return. And that's the way the current reasonable basis rules work, as long as it's disclosed in advance. The Treasury could just amend the list of sources that qualify for reasonable basis to include answers provided by EDA, as long as the taxpayer prints it out and submits it with the tax return. In terms of the way EDA is designed, another possible approach could be to change that so that taxpayers could easily reproduce a written record of every input into EDA and the ultimate answer. You often get that when you use different websites where you're seeking customer service today in the private sector. Today, when you use EDA, it's not really possible to do that. You just get an answer at the end. If you try to claim I had reasonable cause and good faith, you may not be able to show all of the steps that occurred as you answered the questions and the ultimate answer that you received. An easy reform could be to allow taxpayers to have that record. Another possibility could be that IRS officials could change EDA so that taxpayers have to submit personal information, maybe even your social security number, in order to get a time-stamped, date-stamped electronic copy of all of the questions and the answers when you use EDA. And then you could use that to make a reasonable cause defense. Those are just a few ideas. I'm sure there are many, many others. I'll just conclude briefly by talking about the future. How should automated legal guidance evolve? Should it rely more or less on Simplexity? In the future, it's possible that AI could examine your financial and other relevant transactions, including, for example, business trips, medical expenses, and the like, by monitoring your email, your bank records, your flexible spending accounts, all of this. And seamlessly, AI could fill out your tax return. Would that be desirable? What are the costs or benefits of that? We believe that our analysis in this article is essential to thinking about that future question. One of the principal costs of maybe what we can think of as future AI is the ability of people to understand what the law actually is. More sophisticated forms of AI may avoid the costs of Simplexity by making everything so seamless and easy, but some of the issues inherent in the current forms of automated legal guidance will persist and new dangers will be introduced. So in this paper, we have offered a roadmap for how governments should evaluate these trade-offs and minimize the costs as automated legal guidance evolves. Now with that, I'm going to just stop sharing my screen. So I will now stop sharing the screen, and thank you for indulging me as I took a while to describe the whole paper. Our paper is currently, I know Leandra and Leopoldo have circulated it. We'd love comments. As I said, we are continuing this paper and additional extension and possibly even more work in this series. So we'd love your feedback, and I'd love to hear any questions or comments that you have. Thank you very much.